This is the operation of law in Quebec, stemming from the Code of Civil Procedure, Article 95, about notifying the Attorney General concerning our human rights and fundamental freedoms, unless the Attorney General has previously, now notice that, received a notice in accordance with this section. No provision of a statute of Quebec or Canada, of a regulation made thereunder, of an order in council, or of a proclamation of the Lieutenant Governor, the Governor General, the Government du Quebec, or the Governor General in Council, may be declared inapplicable constitutionally. Now you see that. The reason for our contact to them is to declare that their law is inapplicably constitutionally against us. Now, it may not be declared invalid or inoperative or of no force or effect, including in respect of the Canadian Charter of Rights and Freedoms. Without that notice, doesn't work. Such notice, that notice to the Attorney General, is also required when a person sues the state or the public administration for compensation for a violation or negation of the person's fundamental rights and freedoms under the Charter of Human Rights and Freedoms or the Canadian Charter of Rights and Freedoms. So, as you see, this notice is very important. It's a foundational document where all your actions will stem from, and failing to render or send such notice can place what you are trying to do in jeopardy. The British Columbia Constitutional Questions Act. An application is made for a constitutional remedy. The law must not be held to be invalid or inapplicable, and the remedy must not be granted until after notice of the challenge or application has been served on the Attorney General of Canada and the Attorney General of British Columbia, in accordance with this section. So here we are seeing the same operation of law that is present in Quebec is present in British Columbia. We are under obligation, lawful or legal obligation, to send a notification, a notice, to the Attorney General of the province and of Canada. And this notice is our claim for recognition, our claim as that human being. What we are seeking to do is send that notification to the Attorney General long before we ever run into trouble with the government agents, long before we ever need to call on a constitutional challenge in order to change our designation and not be recognized as that legal person, the juridical personality. So this notice should be sent hopefully before you have trouble. It doesn't really take it. You can do it 30 days before you have to appear in court, but it's better to do it a long time before and establish your recognition with them. We find the exact same operation of law that is present in Quebec and British Columbia, present in Manitoba. Constitutional question. Again, we have the obligation, as the one who is challenging the yokes and the burdens of the system. It states that notice to Attorney General is required where in a cause, matter, or other proceeding, the constitutional validity or constitutional applicability of any law is challenged, or an application is made for a remedy. The law shall not be held to be invalid, inapplicable, or inoperable, and the remedy shall not be granted until the Attorney General of Canada and the Attorney General of Manitoba have been served with a notice of the challenge or the application in accordance with this section. So notice again, there's an obligation to serve both of them, the Attorney General of Canada and the Attorney General of Manitoba, or whichever subsequent province you are living in. And the Attorney General of Canada and the Attorney General of Manitoba have replied and have been heard, if either or both desire to be heard. So here in Manitoba, they're even telling you that the Attorney General has to have a chance to be heard concerning this case or concerning whatever you are trying to exercise. Now we take a journey over to Ontario, and again we find the same operation of law. It's present in Ontario. We're looking in the Courts of Justice Act, Article 109. It says, notice of a constitutional question. Notice of a constitutional question shall be served on the Attorney General of Canada and the Attorney General of Ontario in the following circumstances. And then it names the circumstances on which the Attorney General must be served or must be notified. He must be notified, or they must be notified, for the constitutional validity or constitutional applicability of an Act of Parliament of Canada or the legislator, of a regulation or bylaw made under such an act, or of a rule of common law is in question. So, when you want to express or stand under your human rights and fundamental freedoms, and you realize that the acts, the enactments, the regulations that the legislators are passing have removed your rights and freedoms as found internationally and as found domestically in the Charter of Rights and Freedoms, then you have the obligation, before you go forward, to shake off that yoke, that burden, to notify the Attorney Generals of your province and of Canada. In the Canadian Charter of Rights and Freedoms, 1982, Article 24, anyone whose rights or freedoms, as guaranteed by this Charter, have been infringed or denied, may apply to a court of competent jurisdiction. Now notice that, competent jurisdiction, to obtain such remedy as the court considers appropriate and just in the circumstance. So, the Charter is teaching us that there is still a court that is here in Canada that has competent jurisdiction to hear a constitutional challenge. Canadian Charter of Rights and Freedoms, Article 26. It states that the guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. So when we read the Charter of Rights and Freedoms here in Canada, we see certain amounts of freedoms and rights that have been enumerated within the Charter itself. However, Canada is admitting through the Charter, by this article of law here, that there are other rights and freedoms that are available here in Canada that have not been articulated in the Charter itself. And you, as a human being, when you find these rights and freedoms, you can claim them and exercise them. And this is your guarantee, Article 26. Article 32 of the Charter states that the regulations and the obligations that are found within the Charter, they apply to the Parliament and Government of Canada in respect of all matters within the authority of the Parliament. So, whatever rights or freedoms are expressed in the Charter of Rights and Freedoms, they are binding upon the Government of Canada, and they are binding upon the Parliament of Canada. The legislators of each government and province, the ones who make up the rules, the laws, they are under obligation to abide by the rights and freedoms found in the Charter. This is their obligation. Parliament or the legislator of a province may expressly declare in an Act of Parliament or of the legislator, as the case may be, that the Act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Section 7 to 15 of this Charter. So, if the government wants to strip you of the fundamental rights or the freedoms that are found in the Charter, they have to, when they enact their laws, their enactments and their regulations, they have to state in that enactment that these laws will stand despite the Charter. Failure to include that notwithstanding provision renders them impotent, without power, against the Charter. The Canadian Charter of Rights and Freedoms, Article 52 reads this way: "The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect." What that is saying is the rights and the freedoms that we find enumerated in the Constitution of Canada, more specifically the Canadian Charter of Rights and Freedoms, 1982. Those rights and freedoms that we find enumerated therein, they are the supreme law of Canada. And if any province or any other law is put into force that is inconsistent or that goes against the rights and freedoms of the Charter, then they are of no force or effect. They can be nullified, they can be rendered, well, useless. In Section 7 of the Charter of Rights and Freedoms, the verse starts off like this: "Everyone has the following fundamental freedoms." Now, when you look at the justice system of Canada and the justice system of each province, they are under obligation to take judicial notice of what I am about to read. There is judgments within the court systems that state the following: Section 7 of the Charter was intended to confer protection on a singularly human level. A plain, common sense reading of the phrase "everyone has the right to life, liberty, and security of the person" serves to underline the human element involved. Only human beings can enjoy these rights. Everyone, then, must be read in light of the rest of the section and defined to exclude corporations and other artificial entities incapable of enjoying life, liberty, or security of the persons, and include only human beings. This is telling us and teaching us that when we read Section 7 of the Canadian Charter of Rights and Freedoms, that the player or the subject being brought forth in that article of law is a human being, and not the artificial person, the Canadian citizen. Section 7 of the Charter of Rights and Freedoms reads as follows: "Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice." So, a human being has the right to life, a human being has the right to liberty, and a human being has security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. As a human being, we have the right to liberty, and this right is an inalienable right, a right that cannot be transferred or surrendered. It is not subject to legal constraint of another. It's unconstrained. You're having power to follow your own dictates of your own will. You're not subject to the dominion of another. You're not compelled to involuntary servitude. That is what liberty is. And that is a right that we possess as a human being. And there is no fundamental principle of law that allows you to strip me of that liberty. None. The manner in which Canada, this state party, can strip us or try to remove our fundamental rights and freedoms as a human being, in no way does it include the right to hold us in servitude. There is no provision of law within the International Covenant of Civil and Political Rights that grants Canada the right to hold a human being in servitude, in bondage, or in slavery. None. They cannot call out a fundamental principle of justice to justify these actions. Slavery, the condition of a slave. that civil relation in which one man or woman has absolute power over the life, fortune, and liberty of another. Canadian Citizenship Act. I swear that I will be faithful and bear true allegiance to Her Majesty, Queen Elizabeth II, Queen of Canada, her heirs and successors, and that I will faithfully observe the laws of Canada and fulfill my duties as a Canadian citizen. Here, the human being is brought under subjection, into servitude, and loses his liberty by being forced to swear an allegiance to Queen Elizabeth II